Hi, my name is Nduka Njoku. I'm your lecturer for PEL 446, Law of Evidence 2. Today we are examining the topic of documentary evidence. We are going to look at the definition of documents. We also examine public documents and private documents, as well as primary and secondary evidence and the condition for admission of secondary evidence. We also look at computer-generated evidence. I believe you will enjoy today's lecture. Thank you.
Computer-generated evidence. I believe you will enjoy today's lecture. Thank you.
You are welcome once again. Today, we are going to discuss the topic documentary evidence. At the end of this lecture, you should be able to define the term document, define public and private documents, discuss primary and secondary evidence, and discuss computer-generated evidence. What is the meaning of the word document in the law of evidence? And the answer is to be found in section 258 subsection 1 of the Evidence Act 2011. It says it includes books, maps, plans, graphs, drawings, photographs, and also includes any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of these means intended to be used or which may be used for the purpose of recording that matter. B. Any disc, tape, soundtrack, or other device in which sounds or other data, not being visual images, are embodied so as to be capable, with or without the aid of some other equipment, of being reproduced from it. And C. Any film, negative, tape, or other device in which one or more visual images are embodied so as to be capable, with or without the aid of some other equipment, of being reproduced from it. And D. Any device by means of which information is recorded, stored, or retrievable, including computer output. That's the definition of document according to the Evidence Act. So document goes beyond ordinary documents or written document. It includes tapes, disc. So that's the definition of documentary evidence. If you look at the case of Chevron and Delivery, the court was the opinion that for a document to be rendered admissible in court, that document must have been pleaded, and it must have been relevant to the facts in issue, and is admissible in law. That is the conditions which every document must meet before it is admitted in evidence. Let's look at types of documents. You have public documents. You have private documents. What is the definition of public document according to the Evidence Act? What's the definition of public document? According to section 102 of the Evidence Act, a public document means this. It said the following documents are public documents. A. Documents forming the official acts or records or the official acts of 1. The sovereign authority, 2. Official bodies and tribunals, or 3. Public officers, legislative, judicial, and executive, whether of Nigeria or elsewhere. And B. Public records kept in Nigeria or private document. That is the definition of public document according to the Evidence Act 2011. So those are the definitions according to Evidence Act. And if you look at the case of House of Representatives versus CPDCN, the court was the opinion that public document is a document made for the purpose of the public using it. It is made for public use, and it is especially used in judicial proceedings and other official proceedings, such as documents of executive bodies or judicial bodies or legislative bodies. He said that the features of public documents, or the characteristics of public documents, is that they are created over a public matter and they are preserved for the public and they're accessible by the public. So that's why they are called public documents. Now, what of private documents? What does the law say about private documents? Section 103 of the Evidence Act defines private documents. It says all documents other than public documents are private documents. So these are public documents. So these are private documents. Any document which is not a public document belongs to the category of private documents. Let's look at primary and secondary evidence. What is primary evidence? What is the meaning of primary evidence? For that purpose, we need to look at section 86 subsection 1 of the Evidence Act. It says primary evidence means the document itself produced for the inspection of the courts. Subsection 2 says where a document has been executed in several parts, each part shall be primary evidence of the document. 3. Where a document has been executed in counterpart, each counterpart being executed by one person, by one or some of the parties only, each counterpart shall be primary evidence as against the parties executing it. And by subsection 4 of that section 86, it says where a number of documents have been made by a uniform process, as in the case of printing, lithography, photography, computer or other electronic or mechanical process, each shall be primary evidence of the contents of the rest. But where they are all copies of the common origin, they shall not be primary evidence of the contents of the original. So subsection 86 tells us what is a primary evidence. Is the document itself, the original document itself, produced in evidence? That is the primary evidence. And if the document was executed in several parts, so each part is a primary evidence. But if the document is a photocopy of the original, that's not a primary evidence. That actually belongs to secondary evidence. And we see that the law defined primary evidence in an exclusive manner. It says primary evidence means, so it means that any form of document which does not fall within the category of this definition is not a primary evidence. And we may have to look at section 87 of the Evidence Act for the purposes of defining secondary evidence. It says secondary evidence includes certified copies given under the provisions hereafter contained in this act. Copies made from the original by a mechanical or electronic process, which in themselves ensure the accuracy of the copy, and copies compared with such copies. Copies made from or compared with the original. D. Counterparts of document as against the parties who did not execute them. And E. Oral accounts of the contents of the document given by some person who himself seen it. These are secondary evidence. And you see that the law defines secondary evidence in an inclusive manner. So he said includes. So there may be other forms of secondary evidence which is not prescribed by law herein. So, but if we look at the primary evidence, the law was very clear and defined what is primary evidence. Now, let us look at section 93 of the Evidence Act. It said, if a document is alleged to be signed or to have been written, wholly or in part, by any person, the signature or the handwriting of so much of the document as alleged to be in that person's handwriting must be proved to be in his handwriting. So that section provides for how documents are proved that they've been executed. Now, in the next slide, you'll be asked or required to provide an answer to the question provided in that slide. discuss the nature of public and private documents. Let us look at computer-generated evidence. It is of common knowledge that before the enactment of the present Act, the Evidence Act of 2011, the law did not make provision for computer-generated evidence. As a result of developments in technology, it became necessary to make specific enactments regarding computer-generated evidence. If we look at section 258 of the Evidence Act, it says, subsection 1, it says computer means any device for storing and processing information, and any reference to information being derived from other information is a reference to it being derived from it by calculation, comparison, or any other process. So that section defines what a computer is, and it made that definition in an exclusive manner. It says means, which means there's no other definition as to what amounts to computer except as provided by the Evidence Act. And if we look at section 84 of the Evidence Act, it made extensive provisions as to how computer generated evidence is to be tendered in court. It made extensive provisions and conditions for admitting such evidence. And we will notice that by subsection 2 of that section 88 of that section 84, it laid conditions for the purpose of admitting a computer generated evidence. The whole purpose of that subsection of the conditions provided by the Act is to ensure integrity of evidence that are generated by a computer, to ensure that that computer was functioning very well at the time the particular evidence was derived from it, and to ensure that the information that was fed into the computer, or the information that was derived from that computer, is the information that is usually fed into that computer in ordinary course of business, to ensure that there is no manipulation. And he also insists that there ought to be a certificate stating that that condition stipulated under section 84 subsection 2 has been complied with. And if we also may have to look at the case of Kubo versus Dixon, and Omishore versus Aregbesola. These are authorities relating to computer generated evidence. Now let us look at exclusion of oral evidence by documentary evidence. We have seen that the way to prove the contents of a document is to produce that document itself, and the law does preclude anybody from contradicting the contents of a document by oral evidence. And therefore, if there's an issue as to the terms or conditions of a contract or a judgment, then it is only the contents of that particular judgment or contract can be tendered in evidence for purposes of proving it. That section 128 provides that when a judgment of a court or any other judicial or official proceeding, contract or any grant or other disposition or property has been reduced to the form of a document or series of documents, no evidence may be given of such judgment or proceeding or the terms of such contract, grant or disposition of property except the document itself or secondary evidence of its contents in cases in which secondary evidence is admissible under this Act. Nor may the contents of any such document be contradicted, altered, added to, or varied by oral evidence. So it simply means that where a document has been made in respect of a particular issue, whether contract or judgment of the court or any treatise, then it is only the contents of that document can be used and oral evidence is excluded. But there are exceptions. Those exceptions are when there's fraud, intimidation, illegality, existence of separate contract or oral contract. So under such circumstances, as provided under subsection 1A, subsection A, B, D, E. So under such circumstances, then oral evidence may be provided in order to alter or contradict the terms of such a document. In the next slide, you will be asked to provide evidence, to provide answer to that particular question provided therein. Discuss computer generated evidence under the Evidence Act 2011. In this lecture, we have looked at the nature of document, the types of document, public document, private document, primary evidence and secondary evidence. We have also looked at computer generated evidence and the exclusion of oral by documentary evidence. I hope you have enjoyed today's lecture. Thank you.